Alimony, or spousal support, comes in four main flavors. Temporary spousal support, sometimes called maintenance, permanent alimony, temporary alimony, and rehabilitative alimony. Temporary spousal support is an award made during the pendency of a case, while between the date of the filing and the date of the decree. Generally, courts aren't concerned with good guy, bad guy stuff. They're only concerned with making sure everybody eats between the beginning and the end of the case. Everybody has a place to stay while they can sort out who gets what in the divorce case. Permanent alimony tends to take the form X pays to Y Z dollars per month until payor or recipient dies or recipient remarries, whichever shall first occur. A court can make an alimony award payable after death or after remarriage by specific order. Under a case called Rodriguez in 2000, the court expanded the 1974 Buchanan factors as a list of what was to be considered by courts setting alimony awards. The financial condition of the parties, the nature and value of the parties' respective property, the contribution of each party to any property held by them as tenants by the entirety, the duration of the marriage, the husband's income, earning capacity, age, health, and ability to labor, and the wife's age, health, station, and ability to earn a living. This test, as set out in Rodriguez, is set out in a chart which is posted on this page of the website. Simple marital misconduct or fault are expressly to not be alimony factors, so alimony is not a sword to level the wrongdoer or a prize to reward virtue. In reality, even permanent alimony is not really permanent. It's permanent until something changes. Most forms of alimony are modifiable upon a change of circumstances, like retirement or health problems, or if the receiving party hits the lottery, because both need and ability to pay continue to be relevant to alimony considerations. Temporary alimony is essentially the same as permanent alimony, except a cutoff date is added, so it would be X pays to Y Z dollars per month until somebody dies, or until remarriage of the recipient, or until X date, whichever shall first occur. Rehabilitative alimony is somewhat special. It's for the purpose of obtaining training or education relating to a job, career, or profession. Generally, think of it as getting back on your feet sort of alimony. The classical situation is what we call the my turn situation, where one of the parties quits school and goes to work to support the other while that party continues to accrue education and training. And then after that education and training has resulted in a job, the marriage breaks up, and the party who did all the work to put the other party through school now wants to be able to go to school to get further educational credentials. That would be a classical situation for an award of rehabilitative alimony. Any award of that sort of alimony should establish the period by which the recipient is to commence retraining. So it's important to learn the particulars of what the would-be recipient wants to have, do, be, how much it'll cost, etc., because the court will have to take those things into consideration in determining whether or not to make such an order. Any alimony award can be made payable in periodic payments or by lump sum, payable in a single installment or in many installments. If lump sum alimony is used, it essentially eliminates the remarriage cutoff, so it does alter the rights and circumstances of the parties. Most alimony awards can be modified as well. Generally, an alimony award is modifiable until the last day of the last month when the last payment was due, based on an assertion of changed circumstances somewhere during that time. What sort of circumstances can be used? There are many. The classical cases had to do with bankruptcy of a very large property award in one case, or even to compensate the other spouse for debts not paid as ordered. Basically, if the property and debt sections of the divorce decree have not been complied with by one party, it is possible to seek compensation by way of modification of the alimony portions of the order by the other party. There is some question as to whether alimony can be made non-modifiable, and if so, exactly how to do so. Those details are best gone over in a specific consultation.